Good afternoon, everybody. It's Saturday afternoon, and that means that it's time for another episode of American Government TV here on the Grace Christian Academy YouTube channel. I hope you've had a good weekend. You should have received your essays back by now, and perhaps we'll talk about them a little bit during class on Tuesday. But for today, we are going to be looking at Chapter 5 of your textbook. Chapter 5 of your textbook, which is an introductory chapter to the United States Constitution. We'll be talking about that today. Now, in Chapter 4, we talked about the sources of dissatisfaction with the Articles of Confederation and why certain groups and interests wanted to replace the Articles with something different in the way of an organization of the government. We talked about the Annapolis Conference. We talked about the first and second meetings in Philadelphia. The second one was the convention where the Constitution was written. All of the states had sent delegates, and the delegates presented the Constitution to their respective state governments for ratification. Now, the agreement that had been reached was that it would take 9 states to ratify. And that was done by state constitutional conventions. This was not a matter of popular vote. Instead, each state held a convention where the different localities sent delegates. Some of those were popularly elected in this, to the extent that they had voting. The voters that they had did choose the delegates. But this was all done by convention. There was never in any of the states a popular vote on whether to adopt the Constitution. Two groups developed during the Constitution controversy that would go on to be the first two political parties. And those groups were, take this down because some of you have mentioned difficulty keeping it straight. The Federalists were in favor of adopting the proposed Constitution. The Anti-Federalists were against it. Once the Constitution was adopted, the Anti-Federalists continued to be less enthusiastic about the whole project, and there were two political parties, the Federalist and Anti-Federalist political parties. To help you kind of keep it straight, keep the players straight, George Washington, John Adams, and Alexander Hamilton were all Federalists. Thomas Jefferson was perhaps the most high-profile anti-Federalist. So that helps you keep things in mind. But 9 states ratified with some conditions we'll talk about in a little bit. And so the Constitution became an effective document, and it became the document that supposedly governs the way we're governed. Write this expression down. The Constitution of the United States or of any country is often called its organic document. And that means it's the document that sets up the government and says this is how it works. So, in Chapter 5 of your textbook, you have the text of the Constitution, and you should read it. I assigned it to for the pre-beginning reading, and I know none of you had time to do that. But you ought to read it. Don't worry too much about remembering everything it says, because I'm not going to give you a test asking you what Article 3, Clause 2 says. I'm not going to do that. If you want to know what the Constitution says, you can always go read it. But you should read it once to kind of get a feel for what it's like. Um, and we're going to talk a little bit about what's in there today. There were several kind of principles, I suppose, that you could say that drove the people who wrote the Constitution. First of all, their idea was they were going to create a limited national government. And what that means is that the idea was the national government created by the Constitution was going to have only the powers given to it expressly by the Constitution. In other words, it could only do the things, the government could only do the things that the Constitution specifically says it can. There were, however, a couple of weasel words in there, particularly what's called the Necessary and Proper Clause, which allows the national government to do whatever is necessary and proper to carry out its enumerated powers, and that's what you call the powers that are expressly stated in the Constitution, the enumerated powers. But the Constitution then says that the Congress can do whatever is necessary and proper to carry out those powers, and there has proven to be an awful lot of room to stretch in that necessary and proper. Second of all, the Constitution gave the national government power to tax, and the power to tax, when used creatively, will allow a government to do anything it wants to. So, although the original idea was that the national government would be one with a set of enumerated powers and could not stray beyond those powers, the idea that our national government recognizes any kind of limits is a myth. That's not true. They're supposed to, but they don't. Second was the idea of separation of powers, meaning that within the structure of the national government, there would be different centers of power that could do different things and couldn't do different things. This is often pointed to as an example of how our founding fathers were especially prudent and knew of the dangers of concentrating too much power in too few a group of hands, and so they separated the powers. And maybe there's some truth to that. They created three different sources of power within the national government, and they're discussed in the 3 articles of the Constitution. The legislative power, which is discussed in Article 1, and that's the power to pass laws. And Article 1 deals with Congress. Then the executive power, which is regulated and governed by Article 2 of the Constitution, which is supposedly the power of implementing the laws and policies that the legislature adopts. And then third, there is the judicial power, that's often expressed as the authority to interpret the laws that Congress passes, and that's it. And it is in the Constitution that power is placed in the Supreme Court and then in such inferior courts as the Congress should choose to create. And that's in Article 3 of the Constitution. And they are, supposedly there are limits on the power, in each article, on the powers that each power center, each focus of power, can exercise, and they're supposedly separated. And that is supposedly an example of how the framers of our Constitution were careful and understood human nature. My own opinion is that they were optimistically naive or naively optimistic in thinking they were going to be able to constrain the creature they created. But that's just it. So that's another one of the principles, is a supposed separation of powers. The third one is the idea of federalism. Because the Constitution was supposed to be a limited government, it was going to operate along with the governments of the states. The states retained all of the powers not explicitly given to them in the Constitution. And we talked about that a little bit early on when we discussed the issues of quarantines and vaccinations and making us wear masks. The Constitution does not give the national government a specific, what's called a police power, which is the power to make regulations for the health and safety and welfare of the community. But the states do have that power. Just a moment here. Okay, so I'm back. The states do have that broad regulatory power. The state government has the authority to do anything that the national Constitution doesn't prevent it from doing. And that's the idea of federalism, so that we live under two governments. And the other basic element, or basic principle that supposedly exists in the Constitution is the idea of popular sovereignty, meaning that it is the general population that actually is supposed to govern the country and make these decisions, which is why they inserted in the preamble that business about we the people wanting to do it, when in fact the people really had almost nothing to do with it. But they wanted to give that impression, and they did to some extent allow for popular rule. They created in the legislative branch particularly the House of Representatives, which was to be elected by the voters, directly by the voters of the various states. Now, when the Constitution was written, that was not true of the Senate. The state legislatures selected the senators. And then they created, with regard to the executive branch, in the business of electing the president, they created the Electoral College, which was designed to allow for some popular input into electing the president, but not have the president elected directly. Now, the Electoral College was not a brand new invention. It was copied basically from the Holy Roman Empire, which had a group of kings and dukes and such people called electors who would meet to elect an emperor whenever they needed one. And the Electoral College was copied after that. There's been a lot of controversy about the Electoral College ever since 2016, when Mr. Trump won the electoral vote, although he lost the popular vote. There's been a failure to understand that was not a bug. That was things were set up to be that way because the smaller and less populous states were worried about being dominated by the more populous states, and so they bargained for the Electoral College, and they got it. There is a desire now to do away with it and Perhaps we're going to see that happening depending on how things go in the next election. But if that happens, it will be a very definite betrayal of what the people in the less populous states originally bargained for. It supposedly will make our government more democratic. By now, you may have realized that I do not consider that to be a particularly good thing. But anyway, there we are. And that's basically the structure of the Constitution. So remember, Article 1, the legislature; Article 2, the executive; Article 3, the judiciary. The preamble to the Constitution, the part that says "we the people," conveys no powers on the national government, conveys no rights on anybody, and really has no legal meaning whatsoever. And courts have decided that in the past. You can't look to the preamble to answer any kind of legal or constitutional question, because it doesn't really mean anything. The same holds true for the Declaration of Independence, if you were curious. Those documents have no legal significance at all. I urge you to read chapter 5, and I urge you to read the Constitution and pay some attention to the reviews and exercises. You're going to be given a quiz. The material in those quizzes is going to come from these YouTube videos and from material in your textbooks. So take notes and pay attention, and probably relatively soon there's going to be a test coming down the pike. I'm not going to tell you when, but be ready for that, okay? That's it for this week. I'll talk to you Tuesday. Have a good weekend.